Thank you very much. Thank you to the Whitlam Institute and to Adam for inviting me here to participate today. So the paper I'm talking about today, and there's a fuller version that has been distributed, is about the use by the Whitlam government of the external affairs power of the Constitution and the legacy of the Whitlam government's use of that power. So when the Constitution was framed in the 1890s, one of the powers that was given to the new Commonwealth of Australia was a power over external affairs. And on the election of the Whitlam government in December 1972, that's well after the Commonwealth of Australia had attained its independence, the scope of this power was still uncertain. But Whitlam and his Attorney General, Lionel Murphy, were very confident that a broad construction of that power would provide the constitutional basis of the reform agenda of a Labor government. So this is the subject of the paper I'm talking about today. So the uncertain scope of the external affairs powers at Federation, Australia was assigned, the Commonwealth of Australia was assigned a power over external affairs. But the first time that external affairs power was adjudicated on by the High Court was in 1936, and there were different views expressed on the High Court about it. But the Labor judges on the High Court, H.V. Evatt and Edward McTiernan, argued for an expansive interpretation. For them, quote, "It is no longer possible to assert that there is any subject matter which must necessarily be excluded from the list of possible subjects of international negotiation, international dispute, or international agreement." But it would not be until the 1970s and 1980s, and following actions taken by the Whitlam government, that the ambit of the external affairs power would be determined by several cases of the High Court. And in March 1972, several months before the election of the Whitlam government, the Attorney General's Department of the Commonwealth was asked to give an opinion about the external affairs power. And the Attorney General's Department said that, advised the Department of Foreign Affairs, that there was no current view held by the Australian government on the external affairs power, and that even if the government did hold such a view, it would in no way be binding on the High Court. And up till that time, because many international conventions related to matters in the sphere of the Australian states, the process of concluding and ratifying international agreements was often slow. So many conventions of the International Labour Organisation were unratified by the time of the Whitlam government. And another case in point we've already heard about today from two of our speakers, the Convention on the Elimination of All Forms of Racial Discrimination that was adopted for signature by the United Nations General Assembly in December 1965. Well, Paul Hasluck, who was Harold Holt's Minister for External Affairs, signed that convention in 1966. But the process of ratification was very slow. And even though in 1967 there was a referendum at which the Commonwealth was given power to make laws with respect to the Aboriginal races, the Attorney General's Department advised that that power would not be the basis for a law on racial non-discrimination. And so on the election of the Whitlam government in 1972, the Convention on Racial Discrimination had not yet been ratified. Now, the policy of the Whitlam government on this question was, as Rod has just mentioned, very much more urgent than the policies of the Liberal and Country parties. And I'll just read fully that speech that Whitlam made about Aboriginal Australians. He said, "Australia's real test as far as the rest of the world, and particularly our own region, is concerned is the role that we could create for our own Aborigines. In this sense, and it is a very real sense, the Aborigines are our true link with the region. More than any other foreign aid program, more than any international obligation which we meet or forfeit, more than any part we play in any treaty or agreement or alliance, Australia's treatment of her Aboriginal people will be the thing upon which the rest of the world will judge Australia and Australians. So, with that in mind, not long after the Whitlam government came to power, Whitlam's cabinet authorised Lionel Murphy, the Attorney General, to prepare a Racial Discrimination Act. And the Whitlam government also signed other human rights conventions and authorised Murphy to prepare a human rights bill. Now, the thing that gave Murphy a lot of faith that his agenda, ambitious agenda on human rights, could be fulfilled was his view of the external affairs power. And Murphy, early on in the term of the Whitlam government, gave an opinion to one of his colleagues about the external affairs power. And he said, the judgment of Evatt and McTiernan going back to 1936 correctly states the law on the matter. On that basis, Murphy said, the Australian Parliament undoubtedly could implement obligations incurred by Australia under ILO conventions by national legislation applicable throughout the whole of Australia, subject only to any relevant constitutional prohibition. So although the Whitlam government was not able to get through a human rights bill through the Australian Parliament because of the degree of resistance it provoked, including by Robert Menzies, the former Liberal Prime Minister, it was able eventually, by 1975, to get a Racial Discrimination Act passed by the Parliament. And this was Australia's first major piece of human rights legislation. The Act was very significant because it purported to bend the states to the Commonwealth and was drafted to override any state legislation which may have been inconsistent with the aims of the Covenant. And it was for that reason that the bill was opposed by the Liberal and Country parties. But as I said, the Whitlam government was able to get the legislation through as one of its last pieces of legislation. Now, if we look at the legacy of the Whitlam government's use of the external affairs power, one important legacy was Whitlam's appointment of Lionel Murphy to the High Court in 1975. And he became a very effective judge, so much so that the Liberal Premier of New South Wales, of Western Australia, Sir Charles Court, I quote a letter he wrote to Malcolm Fraser about Lionel Murphy, in which he complains of what he calls as the Murphy Doctrine. And Court complained that Murphy in opposition and in government had consistently advanced the view that under external affairs powers provisions of the Constitution, a Commonwealth government could do anything in Australia regardless of the specific terms of the Constitution. If it had a requirement to undertake the things under the terms of a treaty or similar arrangement made with another country. And writing this letter in 1982, Court was particularly referring to a case that had been decided in the High Court involving an Aboriginal Queenslander, John Kawarta, who on behalf of a group of Aborigines had wanted to buy land for development purposes of the Aboriginal group he represented. This was contrary to the policy of the Queensland government, which said that Kawarta could not do this. The case eventually ended up in the High Court, and the High Court decided that what the Queensland government were trying to do to stop Kawarta buying the land was illegal because it was contrary to the Racial Discrimination Act. And the High Court, by a narrow majority of one, decided that the Racial Discrimination Act was a valid Commonwealth law, not because of the Aboriginal or racist power, but because of the external affairs power and because of that law having been legislated to give effect to an international treaty. A year later, in 1983, there was an even more famous case involving the External Affairs Power, and that involved the Tasmanian Liberal government wishing to build a dam on the Franklin River, which was in land which had been inscribed in the World Heritage List as internationally significant land. And the Hawke Labor government, having come to power, legislated on the basis of the World Heritage Convention signed by Whitlam in 1974, and the High Court decided that the External Affairs Power enabled the Commonwealth to override the states and to stop Tasmania building a dam there. And with that High Court decision, the full effectiveness of the External Affairs Power was decided in Murphy and Whitlam's favour. And just in the last section of the paper, I'll look at the continuing legacy of the Whitlam government's legislative program and its use of the External Affairs Power, and this concerns native title. So around the time of the Kawarta case, a group of Aboriginal people of the Mare Islands, the most prominent of whom was Eddie Mabo, maintained that they held certain native title rights in the Murray Islands in the Torres Strait. The Bjelke-Petersen government said no, that was not right, and sought to stop the claim by passing the Coast Islands Declaratory Act, which sought to abolish retrospectively any native title rights that might exist in the Murray Islands. So Mabo took this to court and contended that the Queensland legislation was invalid because it was inconsistent with the Racial Discrimination Act. And the High Court did indeed conclude that that was contrary to the Racial Discrimination Act, which allowed the full case to go to the High Court, and for the High Court in 1992 to make the very important legal finding that there was a native title to land in Australia. And the Racial Discrimination Act was important again when the Keating government sought to pass legislation to give a framework to the handling of native title, and the Western Australian government then tried to invalidate that Commonwealth legislation, and again the Racial Discrimination Act was crucial in the deciding of that case. So I'll just conclude and sum up. Although the Constitution gave the Commonwealth power over external affairs in 1900, the scope of that power remained uncertain until the Whitlam government decided to rely on the power in the process of ratifying certain international agreements and legislating to give effect to them. Following the defeat of the Whitlam government, Lionel Murphy would play a part in determining the extent of the external affairs power in the High Court. One of the most important legacies of the Whitlam government was the clarification of questions that for long had been in dispute concerning the external affairs power. By the 1980s, it was clear that the states no longer had a treaty-making capacity, that the Australian government had the capacity to enter into treaties on any subject, and that the Commonwealth Parliament had the power to give effect to any international obligation under an agreement binding on Australia. The power so interpreted allowed the Hawke government to win out over Tasmania in the dispute over the Franklin Dam. And although the Whitlam government was not able to enact national human rights legislation, it was successful in passing what was to that time Australia's most important human rights law, the Racial Discrimination Act, by virtue of the external affairs power. Described by Whitlam in 1977 as, quote, a much amended and tentative step in the direction of human rights legislation, the Racial Discrimination Act would play a vital part in the unfolding of the revolutionary legal challenge wrought by the Mabo judgment. Thank you very much.